So we are going to start. Guys, we have to be really excited about this. I don't want like politeness. I want to be like, imagine Beyonce is on stage because she's Beyonce of law. I promise. Okay. I know you might not know, but then she's Beyonce of IP law. She's Beyonce. You know, I see people agree with me. So when I say her name, remember, who is it? Thank you. Okay, we're going to welcome to the stage Elizabeth Linger. I sing how she's a boss babe. I sing. Wow. Wow. Hi. How are you? Oh, let me just press the...
Yeah, I'm good. How are you?
I'm good. Thank you for saying yes. Are you seeing have you seen? She has an iPad. Hata wadanganya. Do you see? She's going to say the truth. Are you ready? So I always start my conversations with the same question. Please introduce yourself to us as you to someone who's never met you. I always say that because the things I think are important about you might not be what you think is important about you. Maybe you want us to know your favorite color instead of like your professional, things. So please introduce yourself to all of us.
Hi, everyone.
Guys, that's not how you say hi to Beyonce. Let's do it again.
Where are the ululations?
I know. Where's the... Oh, my God.
So I'm Liz Lenjo. I am a mom and a wife. 2 kids. One husband.
Ni muhimu kujua. It's important.
The jokes and they say one wife, one husband. And I'm an advocate of the High Court of Kenya. I'm a lawyer for the creative industry, the creative economy. My journey started off as a musician, and then I realized we didn't have lawyers who understood the space, and not just music, but film, but just creativity as a whole. And that was because even I used to model as well. So I had a situation where I needed a lawyer. Let me tell you, I window shopped. Hey, I looked. Guys are like, no, there's no such thing. And I'm like, there is. And those are the days you'd go to a cyber printer page and you go with a page and say, but there is something like this, yeah? So that's what shaped me to become an IP entertainment lawyer. So I specialize in intellectual property, entertainment, media, fashion, and technology law, and sports law. So I'm basically a lawyer exclusively for the creative economy. So if you come to me, you want to buy land, I have partners. I wouldn't try to lie to you that I can help you successfully buy a piece of land. I can, but I think it just bores me. So I run my own practice, my IP legal studio, and we specialize in these areas of law. So we essentially help creatives to identify the intellectual property, protect the intellectual property, and by protecting, it's not just registrations, but it's the contracts. It's how you pitch, how you talk to people, how you package yourself, also how you tell stories, because we've been in the space enough to even tell what also, like VCs are looking for. And then, of course, we have the defensive lawyering arm, whether either we are defending you in court or through mediation or arbitration and whatnot. So, of course, defensive lawyering, fee note is like times 3, times 4. If you come for protective lawyering, it's cheaper. And aside from that, I serve in the Copyright Tribunal. I'm the chairperson of the Copyright Tribunal. I was the youngest chairperson to be elected when I was elected 3 years ago.
Beyonce. You see, guys.
So I opened the doors for young lawyers, because now they saw that we can be appointed on merit, and you don't need to wait to see an old guy who's like, to believe that they know something, right? So I'm happy to sit in that position, and we're doing great things, and we'll talk about that at some point as well. But yeah, I'm basically everything creativity. So I love what I do. I love when I watch a music video and I did the legal, and I tell people, that's me, I did the legal. So I've represented clients from music, film, podcasts, business hubs, video game developers, like all manner of creative sports people, whoever you can think of, film production companies, distribution platforms, you name it. I have worked with them.
Amazing. Oh, you see, at AfriPods, we bring you the best, okay? This is why you need to host your podcast with us, because we are the best. Okay, that was a shameless plug. Anyway, so when it comes to podcasts specifically, right, who owns the rights to a podcast? So I've sat down, I've decided me and my co-host are going to create a podcast. Who owns the rights to it? Let me start with what are considered rights when it comes to a podcast? What are the things that can go under legal in a podcast?
All right. So what are the properties or IP assets in a podcast? We start with the name. Yeah. So the branding around the name. And of course, when you're branding, you have to make sure that your name is not misrepresentative or misleading of already existing trademarks out there. So again, you have to do some due diligence yourself and also through a lawyer. And that's usually the first thing you need to do is before you even go out and say, hey guys, I have a podcast called X, you need to go and do your homework, because you can imagine you're in a situation where you spend all those legal fees, or, you go register even the business name and you decide the business name or the company name is also the trademark, right? You do all this and then you're told it's not available. You've done your marketing, you've done your website, you bought your domain name, and then you're told, stop right there. You're given a cease and desist, yeah? You lose a lot of money, yeah? So that's the first thing that we usually tell creatives you must do. When you have that aha moment, do your research, your homework, make sure you do the legal first, then it will be cheaper. So make sure that name is available, it's usable, and it makes sense. And as you're doing that, also when you're creating a podcast, you also want to figure out how you're going to monetize, right? And you want to do that in the beginning, because with trademarks, you're only protected in the classes which you declare. So when you're registering a trademark, we have what is called the NICE classification. So we have goods and services. So most of you guys, podcasts will fall under services. But you may end up doing also other stuff like merchandising and all these other things. So depending. So you want to do that in the beginning so that you capitalize and register those classes at the beginning. Because especially if you're using like English words, some ordinary words that we like to use, and then you missed a class and then you want to register like 3-4 years later, someone else may have been seeing what you're doing and then they'll register in another class. And it's legal. Yeah. So if you failed, then too bad for you. I'll give you an example. A case law. This involved the iPhone. So when iPhone at the beginning they started out, they didn't think we'd have these two covers. Yeah. So then they only registered in the class for phones and whatnot. Then some company in China decided to start making now the covers in leather, in plastic or whatever. They called it iPhone. So, and they had to sue. And unfortunately, because how trademark law works, they were told you didn't declare the right, you're not protected in this class, so you have to figure it out. So they had to negotiate and now buy off that trademark. So do you have time to do that? See, you just do it from the beginning and save yourself the hassle. So aside from trademark, so that trademark means a strategy must be in place because you're about the money, yeah, not just about vibes. Then there's a copyright element. So now this is the content you create. So within copyright protects literary work. So this could be your scripts. It could be any other, representations that you may have, maybe drawings, caricatures, or whatever that you may want to accompany your podcast in terms of content. The sound recording itself, once you're done, preparing the content and you have the final product, it's protected by copyright. But to secure your copyright in that, of course, means contracts, right? And that speaks then to, again, now who owns these assets. So if you're a sole podcaster or a sole proprietor, it's all yours. But the minute you are 2, 3, 4, 5, a conversation must happen. And most creatives never have those conversations. They're like, we are moving with the vibes, the feelings, we're feeling good, until something happens. And most of the time is when someone waves dollars at you and then you're like, no, me, I deserve 40% sort of thing. So again, when you're starting out, those are conversations you want to have from the beginning. You have to have candid conversations. Remember, again, you're going to be investing. Where is legal fees coming from? Yeah. So you agree. You're putting in 20%, 20%, like that. We want to be equals. If you're not equals, if you're putting in 40%, then we agree, even in terms of IP ownership, in terms of decision-making rights, all that stuff. It has to be agreed at that point, and a document is put in place, an agreement is put in place. Then that way you can agree on who owns the content. If you end up doing a collab, also, again, just because I'm here, I can't assume it's yours. Maybe I even want rights, right? Not that I want rights, just making sure. But,
I should have looked for a lawyer to prepare me for the lawyer.
Yeah. So, but you see, I could do that. So you have to have those conversations, right? So maybe I have my own podcast, but I feature in your podcast. Can we have a conversation about what happens to that recording? Yeah. Is it going to be on your platform or my platform? What's the conversation? If you're monetizing on your platform, how are we going to deal with what you're going to earn from what we created together, sort of thing? So it's really important. Again, when you're creating a podcast, sometimes you may be hosted on some platforms that may want IP rights. So then you also have to be smart in terms of the platforms that you're going to upload your content on, so that then you make sure what you've created is yours and rightfully yours. Otherwise, you might find yourself in a situation where you have given up, maybe whole or in part. Yeah.
Okay, so you talked about the rights to the podcast content, right? How do you manage ownership as a podcast host with your guests? Mm-hmm. You mentioned collaborators and co-hosts, because I'm sure there's different ways we would go about each of them.
Yeah.
So what are the ways you can protect yourself ideally as a podcast host with your co-hosts, with the collaborators, and with your guests?
All right. So the best way to protect yourself is through contracts. And I don't know, for some reason, we always shy away from contracts, or we always wait for a deal to come. Then we're like, okay, now we can agree. But you have to agree from the beginning, right? So that there's no misunderstanding, there'll not be drama, no bad blood, relationships won't be ruined. We see that a lot. So you have the agreement. So like with your guests, for example, you would do a model release form. I highly discourage people from self-lawyering, because this legal landscape keeps changing. Yeah. So even the kind of release forms we used to do, like in the mid 2000s versus now, have kind of changed because of the introduction of the Data Protection Act, right? So there are certain clauses, even if you chat GPT, things might not go so well for you. So you would rather go to a lawyer, they help you, and then they can even now give you something that you can use through your business. As long as your business strategy is the same, you have that document. The minute something changes, then you come back and say, hey, I want to do 1, 2, 3, 4. Am I covered? So it's the contracts you will have with your guests. Again, sometimes it will depend on the kind of guest you have as well. What are they bringing to the table? What value proposition? So you have to be candid. So of course, if you're going for like the Beyoncés, negotiating power is different, right? So those are the conversations you want to have, and then have it in writing. And then make sure you back up your contracts. So there's this thing we've seen, especially since COVID. People send each other contracts, alafu they forget to sign. And then someone will come and say, but we didn't have a contract. They didn't sign. So, of course, there's even an agreement by conduct, right? But I think you should have a fully executed agreement, even if it's digital signatures. Once I sign, you sign. You send me back a fully executed one so that I have it, because maybe I signed first, right? So I think it's really important that we do that, because we've been seeing guys trying to claim differently. If you're co-hosts, we need to agree, what does a co-host mean? Yeah? What do I want? What do you want? Again, conversations we usually don't have as creatives. We wait until something bad happens and then we start jumping ship. Yeah. So again, with co-hosts, it should be the contract. And I know it gets tricky when you're doing business with your sister, with your cousin, with your relatives especially, or your best friends, from nursery school. I once had a case like that where two friends who knew each other from when they were kids, and they were collaborating on a film. They never did an agreement. And then eventually one of them decided, bye-bye, toodles, I'll go and work with someone else. She finds a trailer with her script of her script on YouTube. It was a whole situation, yani, and it was like fists. It was serious. So they're like, oh, we thought we trusted each other. So it's always important to have those conversations and have a contract. So again, it will depend with who you are working with, and that contract should mirror what each party wants, what obligations and performance looks like in a contract, so that then you're able to say, if you do 1, 2, 3, 4, this is what you get in return. And if I do 1, 2, 3, 4, this is what I get in return. Because then that way I can measure lack of performance of the agreement. Then I can say, we'll terminate this agreement when you don't do
something. Okay.
Yeah.
How does that change for podcasts that work with networks? Because a lot of times the networks are covering things like production cost and things like that, even though you might own the IP for the thing. How do you then determine what the split should be or what the contract should be like in such a situation?
So in such situations, you find it's an issue of investment, right? Because these people or this person or this platform is putting in some money, right? So because they're putting in some money, they probably want a return of investment. So you have to have a candid conversation on what does that ROI look like. And then you have an agreement. If you have a trial period, let it also reflect. If it's a barter, let it reflect. If it's revenue share, once you start making revenue, let it reflect, so that every step of that engagement, because for platforms, it's all about money. How do they get their money back and invest in other things? So then it has to be very clear. It has to be very clear to a T, what are they investing in, such that if you are putting in some money for something else, it's also very clear. You don't just put in money and say, no, but I thought I put in X amount of money to do 1, 2, 3, 4. And, so it's very clear. If Kadhoni is putting 40,000, 40,000 is for X. As the platform, I'm putting in money for crew, space, it's put down, right? And then we agree what that ROI looks like.
Is there space to be able to change contracts as they go? Because like you're saying, it might be something like monetization, where you put in 40,000, but now I need to add 60,000, for example. How do you edit the contract in that sense?
So you make a provision where you can be able to renew the contract. Because sometimes you're able to project what may change. You see, like maybe you say, maybe in 3 months, I can put in another 60K, right? So then we have a provision in the contract that either says in 3 months, we will review the contract and renegotiate or something like that. So the danger we normally have is we usually try to have those long contracts, 3 years, 5 years. They look short. See, they look short, right? 3 years is a long time for a creative. 3 years is a long time to do business with just one person. It's a long time. So we always advise you stagger it. Either do it periodically, every 6 months or every year. Because then you also suss out if they're, a good partner or a good fit for you. So that if they're not, you're able to leave. Again, if you self-lawyer and do the contracts yourself, you won't be able to see some of these curveballs, Indio. Yeah, but someone like me will be able to say, look out for 1, 2, 3, 4. Yeah. Let me put it at that.
Okay. Now, I don't have money for a lawyer. What are there words that you can see in a contract that you would tell a creative, if you see this word, immediately no, or if you see this word, call a lawyer? Because we might not all have access to the lawyer. Some of us, our lawyer is ChatGPT for real. So how do I get access to or know the information as just a normal person?
Okay. So let me give you a cheat sheet on how to tell if you're about to get into a bad contract. Number 1, the minute you have more than 15 pages, there's a problem. What can I not say in 5, 6 pages in even layman language? Because and that's a mistake we sometimes do as lawyers, especially for the creative space. I want to give you that English for the nose, big words, yeah? And you have to read with a dictionary next to you or ChatGPT. Please define, yeah? So the minute you see a bulky contract, there's a problem. The minute the font is small, there's a problem. I'll tell you for a fact, because I have read contracts. The font was for, I almost need a magnifying glass, and it was like 50 pages. So the minute you see it's bulky, the font, already red flag. And then you start looking for words like perpetuity. You look at the territorial clause and you see things like for the whole world and then everywhere. There's a problem. then look, at least glaze through the payments or what we call the consideration clause, what's in it for you. And say you had a conversation, and then what you had agreed with versus what is on paper are not on the same page. There's a problem. Yeah. So at least those ones help you in the beginning. Yeah. And then also, when you're told you have 24 hours to sign a contract, Connie, it's a hostile takeover. Eh? I thought it was a partnership. Why? Why do I have 24 hours? Why does your lawyer have 48 hours? Yeah. And the kind of due diligence for me when you bring a contract, it's not just about looking at the contract. I'll suss out these guys. I'll come and tell you, maybe they have a litigation history. This is their street cred, nini. Then I'm able to tell you, the way you want to do business, this might not be the partner for you. 24 hours, I can't do that. 48 hours. There's some searches maybe that are government office oriented, might take 5 days, 3 days. I need to make some calls. So even for you as a creative, as a podcaster, when you're told you have 24 hours or 48 hours, a time limit to make a decision, then pull back, right? Si lazima. It shouldn't be a hostile takeover. A contract is a negotiation. It's supposed to be a meeting of the minds. Yeah. But again, when let's talk about being able to afford a lawyer. How much do we spend on our hair? How much do we spend on our shoes, on our swag? Yeah, it's something you can save for. And remember I said protective lawyering is cheaper than defensive lawyering. If you come to my office and say, Liz, I would like a consultation, I have, what is your rate? Maybe it's 10K or 15K, but you're able to say, this is what I have. Maybe you even say, we can barter. I can do this and this. We discuss, right? Because lawyers are also humans.
Exposure.
Yeah, we will figure it out. Of course, it's a cool exposure, but we'll figure it out. We'll negotiate, right? Because sometimes you can see talent, you can see where it's going and whatnot. So we negotiate. And when it's protective, it's something I can do with my eyes closed. Even it's a conversation, you take notes, I prepare you for your business, what's ahead. Then now you're able now to plan and say, okay, I need, if it's trademark, this is the kind of fees I'm looking at. I need this kind of contracts. Then you have even a strategy or a plan. So that then now because it's a business, you're investing in it as well, right? So then you're able to have a strategy. So I say when it's at protective stage, it's affordable. It's doable. Start with a consultation and then figure out how are you going to raise money for the different things. And then figure out if you need to have some of them either automated or templates that can serve you for like 2 years, it's doable, right? Because again, we have discussed, you've said, this is how I want to do business. Then I equip you and you have enough for those 2 years. And then now also, I equip you to know when you really need to call me. Yeah, I prepare you to maybe protect yourself in some spaces. And in some spaces, I tell you, hey, if you see this, please just call me and tell me. If you see this kind of document, there's a problem, So, but I think you can afford a lawyer if you need it, if you really want to.
Okay. You talked about the different types of intellectual property that you have as a podcaster. You touched on copyright and trademark, sometimes having both. How do you determine as a podcaster which one you should go into? Is there one you can go into first versus the other? And then can I do it after? So after I've done everything, can I go and trademark after I have put 10 episodes, 15 episodes out? And would it affect how it is then considered legal?
All right. So the thing with IP is, you see, you're creating something that you can be able to say it's yours. So at that point of creation, you must be certain you have that ability to own it. So if you want to backtrack, things might be difficult for you. Remember, I made that example. You've even put out the content, you have this domain name, and then the next thing you're slapped with a cease and desist or a notice saying, oh, actually, we have this trademark, you can't be using this domain just because we didn't buy .ke and we have .com and all these others. There's already some issue of maybe misrepresentation or whatnot. So you want to be able to have done this beforehand, especially for the branding, because podcasts are really heavy on branding. Yeah, it's about the identity and the brand that you create. So you have to be certain at the beginning, because you don't want to be in a situation you've spent all this money recording and then you're being told to take it down. You've spent half a mic, you've spent 70K, you've spent some money, you're being told to take it down and you can't use it forever or ever. It's painful.
It is.
Yeah. So you want to be able to do that. The good thing with copyright doesn't need a registration. The minute anything copyrightable, we're talking literary works, artistic works, sound recordings, musical works, because you may create a jingle for your podcast, right? So all those things that you create, the minute they become tangible, they are they're fixed. Then automatically they are protected. Registration is something we recommend because of especially purposes of evidence. But again, podcast, it would be very cumbersome. Every episode, upload. It can be cumbersome. So when you have your copyright notices, it's enough. And then, of course, you have your contracts and whatnot. You sort of cover yourself so that you don't necessarily need to, unless it's a very special show, there's maybe some script aspect to it, then we're able to help you and say, okay, there's some elements we can register because we see these dangers, and then the others you can. So you see, again, self-lawyering, there are some things you might miss, right? And at a protective stage, we're able to advise you on that. Again, when you're talking about IP in a podcast, there's also third-party rights, like music, yeah? Do you have the right to use this person's music? Because the basis of intellectual property is that if it does not belong to you, you must clear the rights, yeah? IP and Shamba, the same thing. It's only that one you can touch or you can live in, and the other one, you can feel it and you can make money from it without touching it per se, but you can experience it. So that means you have to clear the rights. You have to talk to this person and say, I have this kind of podcast. I'd love to use your song. Because with copyright, we also have what is called moral rights. Moral rights speak to the power for a creator or an author to say, if it's used in this manner, it will paint me in bad light. It will sour my reputation. You will have distorted, and it will look or feel different, or it just doesn't. It's not what I want, right? Those are moral rights. So for that purpose, then you make sure that you and the other party are aligned, and then you have an agreement in that regard. So we take that for granted. So even sometimes it might be as small as a painting on your background. How many of us even think about the background when we are putting together a set for our podcast? We never, Senor. We don't, right? So meanwhile, there's a Picasso somebody, and then they see you, and then there you had like a very serious brand that has, branded or, is sponsoring your content. Kwisha wewe. Demand letter. And I assume you've made 5 million. I'm asking for 4 million. Yeah. So
after tax, you have nothing.
Exactly. So again, when you're curating even a set, you have to be very deliberate with the IP. And when you're deliberate with IP also, you figure out value additions or propositions for the people you'll work with, right? I might get furniture, and then this is also copyrightable, right? So I can say, if you give me furniture for my set, I'm giving you free marketing. You have free furniture, yeah, and you have an agreement somewhere, right? They'll give you furniture for the rest, for your 12 episodes, for example. So with that sort of engagement, so because everything is IP when you look around, right? So if you're smart about it, you find even ways to save money, yeah, because then you're able to barter with the different creatives and whatnot. So again, we don't think about the surroundings in a podcast. So you never want to be in a situation where you're being flagged for infringement. I think that's all I have to say in regards to
on my brand. So say I have a podcast logo and it's starting as my podcast logo, but I'll use it for merchandise later. Is there a difference in how I'll register it, copyright versus trademark? Because you'd mentioned sometimes for goods and services, it's different. And I feel like merchandising might fall under goods.
Yeah.
So is there a difference in how I put the logo out? If I know it will be used in merchandise, or how does that work?
Okay. So if you've already established this is your brand, you're doing it for podcasts, and then the same visual aspects are what you would put on clothes or something, or even mugs, then they're in the merchandise category, and then it will depend on the merchandise. So it's not just at one class for merchandise. There's one for clothing and apparel. Then there'd be some for like cups and utensils and whatnot. Maybe there'll be some for furniture, for bags and da. So it will depend on the kind of merchandising you're doing. And then, of course, you're actively selling and marketing and all that stuff, because also, again, that's how you're asserting yourself and you're asserting your ownership. There are those who trademark and then they just sit. They do nothing with it and they're thinking, I'll just wait for money to just fall from heaven, or wait for someone else to use it and then I go after them. Yeah. And again, that is something that we can fight legally because there are provisions for that. Yeah.
Okay. You had touched on music earlier, use of music. There's a lot of music podcasts. Someone here just mentioned they talk about like Kenyan music and culture as well. What are the legal requirements for using music, sound effects, third-party audio, news clips, excerpts, things like that in a podcast?
Okay. So I had mentioned the issue of if it's an already existing song, find the owners. Now, music is tricky because with music we have copyright and related rights in music. So copyright will speak to the composition, the melody, the lyrics. And then we'll have the sound recording. Those are the two kwanza that you really have to clear and make sure you have the right, people signing the documents. Because the performer usually is more, they are compensated for their role and then maybe they get royalties from their collective management organization. But the two major rights you have to think about is the copyright in the music and the sound recording. So if I decided I take a song from, say, Calligraph, yeah, and I'm playing it in my podcast as is, I have to know who are the writers of the song. We have an agreement. Pay them separately. If the producer is another person, then I clear the sound recording right and have an agreement. If you're lucky, the two of them might be one and the same person. You have an agreement, comprehensive agreement, and you sign. Then you license. Because if you don't license, they'll come after you, right? Remember, if it's not yours, it's infringement. Then there's options of using royalty-free music, like YouTube has a library. But make sure whatever source you go to, read the terms and conditions and understand. Because there's some platforms that purport to give royalty-free music. Some are free, but free is not free. So you must read the terms and conditions. Don't operate on assumptions. Then in some instances, you may be able to claim fair use.
What is fair? Okay,
yeah. Getting there. So fair use is an exception to copyright, where you don't necessarily need permission of the rights holder, right? In copyright, especially, where say it's a podcast, we critique books, for example. I don't need to go to all the authors and I'm reviewing your book. Please give me permission. You see, because of the nature of the use, and we are not like giving a cheat sheet, don't buy the book, we'll tell you the story, right? We're just actually discussing maybe the writing style or whatever. We're critiquing something, then we're able to do that. Or if it's a commentary, so-and-so launched a book, so-and-so launched music, and you play like half a second or whatever and say, that beat sounds good. Like, does it remind you of? It's a commentary, it's, and sometimes parody is allowed. Parody, my age is about to show. You remember Kajairo? Because those were the days. Parody was the thing. For the Gen Z in the room, I advise you to just go to YouTube. But you know how you take a song and then you make fun of it, maybe to mock a political situation or some societal issue, to make fun of it and make light of a moment. So parody, of course, in that situation is possible. Then news clips, you may use them, but again, it will depend on the context and the nature of your podcast. So when you're trying to use third-party IP, I always say you need an extra eye, which would be a lawyer, to make sure you're not in trouble. Because like news clips, you see, we also have copyright to broadcasting. So let's say you decided you may want to feature an excerpt of some KBC news, right? So again, we need to investigate how you're using it so that we know whether you fall within fair use or you may end up actually needing to clear the rights. So you have to be very strategic in how you do that.
Okay. When it comes to guests and getting do we need to have releases? Is it a must? What rights do they have as a guest coming on my podcast? And what clauses do I need to include in my release forms that would protect me as a podcaster?
Okay. So I'll give an executive summary for at least the generals. Of course, they give you the consent to use the image and likeness and recordings. They give you the permission to be able to put it on your platform. Again, you'll find that you have to be very specific and very detailed because Data Protection Act has changed the scope, right? So you can no longer use those words for, I can use them in whatever platforms I so wish, blah, 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 in perpetuity, those things. Again, under the Data Protection Act, as a podcast guest, I have the right to request for copies or us doing our thing and I use it for my portfolio or whatever. I have that right. So again, now you have to be generous because the law says you must be generous. But at the same time, also when you're creating this consent form or this contract, you also want to be in a place where you can almost control also what your guest is saying because you are responsible for that content. Yeah. So the minute it's published, like say if it's defamatory, you will be the publisher, right? So even you will be jointly liable for whatever they say. So you want to be in a position where you also are able to control the conversation and even tell them areas in which they need to maybe refrain to make certain statements and whatnot, because you can see some liability depending on the topics and conversations you're having. You may also sometimes, actually not sometimes, but most of the time, how many of us think about what we are wearing when we are recording podcasts? Do we think about it? Some don't, right? So you can imagine it's a podcast, let's say, that is X-rated type of material, adult content, and then it's a family brand. You're there wearing a brand that is proud to be a family brand. What's going to happen to you? Okay. You're going to be sued, and then you have to take down that content. So the same thing, you're able to tell your guest how to even dress, what kind of brands. Maybe also you are sponsored, right? So if you're sponsored again, say you're being sponsored again, because this is for purposes of education, I'd like to use an example because there are examples that we know that compete. So say you're sponsored by Coca-Cola and then your guest shows up in a Pepsi t-shirt. Yeah, see, so you have to think about that beforehand in regards to that. Again, something else that's really important is we love to joke sometimes, but some jokes can be too much, especially even on an IP perspective. You may end up mocking a brand and then they'll come after you through IP law. Yeah, it might be an issue where it's a dilution, maybe you're diluting the mark, you're portraying them in bad light, you're interfering with their goodwill and things like that. So again, you have to be very smart with some jokes that you make, right? So that you refrain from having a situation where you're being sued left, right, and center because you're just not making the right jokes. Yeah.
What do you do in the situation for live shows? Because there's a lot of people who are having live shows now, and you have the guest on stage. And yes, I'll have a contract with my guest. What happens with my audience? What's the protection I should have or think about, if any, for my audience when it comes to use of like their images and things like that after the show? Are there things I should consider? Are there protections I should put in place?
Okay, so if you're having a live show, say you're selling tickets, then have some terms and conditions at the time they're purchasing, right? So that they know what they're getting into. Again, Data Protection Act changed how things are done because we talk about informed consent and express consent. Express consent means I have done a certain act that shows, yes, I accept, right? And then secondly, informed means I know what you're going to do with this recording of me. And then you're also now stating, we shall record your face, blah, 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 all these things. So you have to factor that in so that they are aware of it. And then it doesn't have to have multi-layer. So how do you capture that consent? You figure out if you want to use technology, or is it like a sign-up sheet where they sign and it has a big wording there saying, you have read the terms and conditions and you accept to be photographed, blah, blah, blah. You'll have some notices also saying this is a photography and videography zone. You have accepted so you have all that in place. And then again, even in the terms and conditions, you can't use perpetuity and things like that. So you said, I'm going to have this content on Spotify, on YouTube, and da. So the minute you introduce another platform, you may need to clear the rights, depending also on how contentious maybe that new platform may be, right? So you may need. So you want to be smart with the decisions you make at the beginning, so that then you have a less of a headache in between. So make sure you have those clearances in the beginning and not after the fact.
Okay, so you can do it at the ticket point and then have yourself protected in that sense.
Yeah.
Okay. When it comes to monetization, because this is a big deal when it comes to podcasting, if you're thinking about sponsorship, if you're thinking about ad placements, how do you protect yourself when it comes to exclusivity and things like that? So I'm a new podcaster, Coca-Cola has come to me, it's a 3-year contract or whatever it is, it's exclusive. What are the things or considerations I need to put in that space? Oh. Don't do it is right, but what are the considerations for legal pitfalls when it comes to money?
I think first and foremost, you ask yourself whether it makes sense, commercial sense to you. Is it going to open doors or close doors, right? What does that exclusivity mean? Do you have flexibility to make decisions? What kind of control are they asserting? Because when it's exclusive, chances are you may not be in a situation of control. Exclusive is a heavy word. It comes with weight. So the minute they decide that 3 years exclusivity, now they decide your content, they decide who you have on the show, they decide what you talk about, they decide how you dress, they decide everything. So does it make sense for you? Again, that contract may come with other sort of padlocks. There are some people maybe we may not also be able to engage in, maybe even other brands, maybe a furniture brand or whatever. So you have to see what opportunities is it unlocking or blocking for it to make sense, so that then now you decide. So again, speaking of words that you see in a contract and you red flags, exclusivity is another one. The minute you see an exclusive agreement, you need to call somebody, especially an IP lawyer, yeah, so that then you're able to negotiate that. Let's see, what else? Well, it's mostly about control, by the way, because as creatives, we're all about control. Yeah.
When it comes to platforms, right? YouTube, Spotify, AfriPods, what are the considerations? I put us last so that you remember, even though we are first. I just want you to note. But what are the considerations that you need to have as a podcaster when it comes to your hosting platform? I know you talked about IP, for example. And a lot of times when we're doing terms and conditions, we're not actually reading through the whole thing. But what are the considerations we need to put in place for our podcasts, but also when it comes to monetization later?
So I think usually the biggest thing is usually the issue of intellectual property. There's the issue of data protection, how you're also handling the data, because you're also, as a platform, you're processing data. And then, of course, then there'll be the issue of how are you making money since you're the platform? Are the podcasters, how do they have the flexibility to make theirs on their own? And what happens to the revenue they make? Or is there you guys are marketing or whatever, then based on what you get, you make some money and split. So it's about also those kinds of conversations. Again, if there's any payments or splits in revenue, how do you handle that? Quarterly, half yearly, yearly, or whatever, all those things. Is it subject to when you make money, or what kind of money as well, or what kind of revenue? Because again, there's a danger when you just put revenue blanket. Yeah, you have to be very specific, because there will be some revenue you as a business, as a platform, that's yours. And then there'll be that is also pegged on what the podcasters are doing, right? So you find those are very important. And then as a platform as well, you need to have checks and balances in terms of the content that you agree to have on the platform. Because again, as a platform, you have what we call secondary liability. As a podcaster, I may do something like defamation, for example. I do something, I'm sued by politician X, but they won't just come after me. They'll come after you as well. So what terms and conditions do you have in terms of at least some regulation or code of conduct for your podcasters so that then you protect yourself? Are you giving them access to music to use on the platform? Might be easier for you, then you have less takedown notices and downtime on access to content and things like that. So you think also about the different types of value add you give your users. So and that speaks also to now how do you even choose the right platform, right? What does this platform have to offer me? What kind of access do I have? Am I able to use different platforms? Because sometimes you may want this platform for this kind of audience, another platform for this kind of audience. So do their terms and conditions allow your content to coexist on different platforms, or are they also asking for exclusivity? Yeah.
Okay, that's interesting because I hadn't considered the different platforms having different terms and conditions when it comes to exclusivity and having to consider that as a podcaster as well. When it comes to thinking about like the platform, right? And this is now completely my curiosity. Is there protection from the secondary being sued as a secondary person? Because now as a platform, can you protect yourself in the terms and conditions so that you're not sued as a secondary if there's defamation or something like that? Or do you automatically, because you're the platform giving the resource, get put under the legal action?
So in the Copyright Act, we have things like provision, what you call intermediary liability. Where the cute in me is about to come out. So you have to, there's some certain control you have as a platform, right? So the minute you're able to show that you did your level best to cure this issue, then you may easily be, remove yourself from the equation. That's not to mean that you won't be sued. You'll be sued, but you'll transfer that liability because you made sure there's some checks and balances and you took care of that and you did your level best. So as long as the court of law is convinced that you did your level best, then the quote-unquote guilty party will be liable for their wrongdoing. Yeah. So it may mean that you either have to shut them down, you may have to block that video or podcast or whatever it is. You may have to issue even a letter, a warning of some sort, telling them they need to take it down or they were crossing a certain line. Like, you have those mechanisms in place. So, because that would be your evidence to show to the court that you did your best. Okay. Then you're able to protect yourself.
Okay. So then, back to podcasters. How can a podcaster in Kenya, Africa, protect or navigate local and international copyright? So when it comes to music and things like that, I know they're not necessarily looking for a Kenyan podcaster who's doing something like on Jay-Z, and if you play the music, they might not come for you now. But then because your content is not limited to the Kenyan audience, once I put it on the internet, I can't control who's listening. How do I protect myself when it comes to local and international copyright laws?
So as much as we say IP laws are jurisdictional, that they are only in that country, some of them are special, like copyright. Because you see, we also have the mother treaties, right? So like Kenya is a signatory of what we call the Berne Convention, the mother of copyright law. And we are mandated as a signatory country to treat foreign copyright the same as we would treat Kenyan copyright. So that essentially means that you have to clear the work, you have to get the right licenses and whatnot, so that then you protect yourself from any liability. So we can't have, under the convention, we can't have mandatory things like you must register or things like that, like in an ideal situation. But in some countries, sometimes they do that. But like in Kenya, because we have a voluntary registration system, we would ensure we just clear. And also for good business, you just clear those rights, especially when you decide to use those hot songs, with music especially. Let me tell you, the big publishers and record labels are always like looking out. And then you land that sweet deal, an endorsement. Aha. You might not even keep a shilling. You end up losing all that money because legal fees, damages and all these things. And then you're back to square zero. So like I said earlier, if it's not yours, clear the rights. You are better off doing that than trying to backtrack.
Where are the places I can go to check rights and be able to clear them? So it's Gathoni, who is trying to use, let me use Jay-Z again. I've really gone with Jay-Z and Beyonce today, but I'm trying to use Jay-Z's song, right? There's something hot happening now. Where are the places I can go to figure out, or even if it's just figuring out how to clear the copyright for them as a small podcaster, because a lot of the people who are doing podcasts are, for example, in their houses, it's just me, my mic in my bedroom, in my closet, under my blanket. Where are the places I can go to figure this out and figure out the costs and things like that, so that then I can protect myself from the very beginning.
Okay. So, of course, you start with an online search. You may start from YouTube, because YouTube, the content usually has the metadata. They'll capture some of them even go to the extent of saying who's the songwriter, who's the publisher, who's the record label, and things like that. And then you'll have done also some research on the artist. Are they represented by a record label? Maybe you will be able to see whether they have like a 360 deal where they're fully managed by a certain label. So then that means you would go to this label and clear the rights and have the agreement and things like that. So you do that homework basically. And then from there, you're able to decide. Unfortunately, there's no way you will know the rates, because this is a personal right. So they decide. They'll decide whether they even want to license it or not, right? They'll decide whether they like you or not. And then they decide how much, and then maybe negotiate. Some of them may also want to hear your podcast first before they clear the rights. So that's, again, another disadvantage of using already recorded songs that are already owned, hit songs and whatnot, because they have to assert their copyright. There are some who want to be privy to what you will do with it before you publish the works. So then you decide, you make a decision. But I would say this, especially for Kenyan podcasters, I think we need to start figuring out how we collaborate with our own musicians, and we open those conversations and figure out what quid pro quo looks like. In my assessment, the reason Nigerian music is huge is because they collaborate a lot. They don't care, quote unquote, how small you are. They are open for business. So much so that's how their penetration is big time, right? So I think it's time now, as podcasters, you decide, can we approach maybe some musicians? Can we approach like Recording Industry of Kenya? They represent record labels, and see what kind of conversation can you have so that you benefit. Maybe their members can be giving some music, create a library for your podcasters and things like that. So I think we need to start having dialogue across our different sectors in the creative space and start collaborating. That way we'll become bigger. Yeah.
Awesome. I'm going to give you a solution thing to do for me. While I'm doing this, I want you to think about your questions. I love you Kenyans. I say this every time. When I ask for questions, I don't want to hear. Mine is not a question, it's a thank you. Are we together? I don't want comments. I want excellent. Okay, so I want to give you an example of a dispute resolution, okay? So you can tell me how we would go about it legally. So it's two friends. We started hosting a podcast on vibes. So no contracts. And then as we're going along, one of us decides we want to monetize, but the other one is still iffy, wishy-washy. We were together from the start. We figured everything together. But then as we go, the one who wants to make money goes and registers the trademark, does all of that, and then kicks me out of like loggings and things like that. And then they start making money. As the second co-host, do I have any rights legally, because I was there from the start, but we don't have a contract? Again, it was vibes, but the other person went and did all of the legal things on their own. What do I have as a standing for myself?
Okay. So remember, we said in a podcast, there's two assets you create. There'll be the copyright and the trademark. Sindio, we said copyright, you don't have to register. You have the copyright in the recordings. You have the copyright in the content, right? So like in that instance, they went and registered a copyright without you. Already there at the Copyright Tribunal, we have express jurisdiction. You bring that matter to us. Why would you bring it to us? First of all, the Copyright Tribunal is very flexible. We're not like a formal court, so you can represent yourself. It's affordable. If you're going to file, you're spending between 200 bob and 1,000 bob. By the time you're done, kienda sana maybe 5K. Yeah. So as long as you're good loaded with your evidence, you can actually represent yourself and you'll be guided. We have a team that helps you do that. And then our turnaround time, you'll have a judgment between 30 days and 120 days max, depending on the nature. So that would be an issue. Registration is an issue. They went and registered a copyright without you. You're challenging that registration. Secondly, they've gone, pocketed some money, and they didn't give you money. Again, that's another second claim, fair compensation. There's money that's also due to you. So again, when you're claiming also, how much money did you make? And you need to pay me, right? Mm-hmm. So already that one is sorted. You would do it under the tribunal. Quick, fast, easy, 30 to 120 days maximum. How many of us here have used courts? Some of us have cases for 5 years, or we know people who have been in court 3 years, 5 years, 10 years, 20 years. So the corporate tribunal is the tribunal for any creative, right? And you can even go smarter and even as we are fighting, we want to quickly resolve this thing. So even if we have this bad blood, we can even, if it's a situation where we would rather come to the tribunal to resolve it faster for us, you write a dispute resolution agreement. It will be like 2 clauses saying we have an issue X, Y, and Z, and we've agreed to submit to the copyright tribunal. And that's it. Then you come and file a document and say, our contract is giving you jurisdiction because it's a copyright issue, yeah? And we're able to resolve it for you faster. So hopefully, even as we fight, let's fight smart, right? Let's not fight to kill each other, finish each other, get each other broke, right? I mean, because today it will be her, then tomorrow it will be you, yeah? The cycle won't stop. So again, we have to be very smart with fighting. And again, you don't want to start fighting on social media. And unfortunately, especially creatives, we are culprits, true or false. We are always quick to go on X, on Facebook, on TikTok, on what, on Snapchat, so-and-so you did, la, la, la. No, please. You get rid of a lot of goodwill. So much so that if you came to me as a lawyer and then you show me videos you did, first of all, my fee will be times 10. It will be a lot of work. Because now even all the goodwill I could have used to help negotiate this case for you, maybe even a beautiful out-of-court settlement, now I can't do that. Yeah? So don't fight, on social media. So at least for the copyright, the tribunal is faster. If there's not too much bad blood, you may decide to see if you can mediate and get a third party, a mentor or something to help you mediate and have an agreement. And you could even go further and figure out how to adopt it as a court order. So even you could go the next level and say you come to the tribunal and say, please help us adopt this, or go to the high court. We give you guidance. When it comes to trademark issues, it gets a little messier because now that you'll have to go to the high court. Yeah. So let's figure out how we can agree, right? Where we've done some wrongdoing, let's figure out how to negotiate, because the legal costs are higher when we are now before a high court. It means then your lawyer has to fight harder and smarter. That's why there's that joke that lawyers are liars. It's just us trying to be smart and witty, especially when you're defending the person who's actually the wrongdoer, right? I have to be smart so that also when I slap you with my legal fee note, you feel like I earned. You saw me sweat. But I'd say where your only option is high court, tafadhali, just settle out of court, get a mediator, an arbitrator or somebody, and they help you figure that out. Again, sometimes you find that if you have the right legal team or person with you, they're even able to tell you, no. You don't need to fight. Because, there will be those who tell you, we can win this thing, let's fight. Yeah, and meanwhile, it's hot air. But a good lawyer will also help you be sober. Yeah, they will help you see where the money is. So you want to be in a situation where you also say, you know what, chick, relax. I think we have someone. Let's talk to someone and see how we can. Even if we are parting ways, at least let's see how we can sever this relationship and we live with something and we are okay. Even if we won't talk to each other forever and ever, but at least I can say I went with something, we are good, right? And atubaki minus, because litigation is minus. It means legal costs, right? And then aside from that, now whoever loses will be paying some damages or whatever. You don't want to be in that situation. So I'd really say let's learn how to fight smart. And the minute the business deal or the partnership is not making sense, let's just part ways respectfully and move on. Again, you never know what will happen in the next 3 years, 5 years. If we leave each other with bad blood and then there will be a day you might need me because of a certain skill I have, how will you come back and say, hey, Liz, I have biz we can do together? So it will be hard, right? So fight smart. That's what I would tell creatives. Fight smart.
Fight smart. I'm coming to you for questions. What did we agree? I'm coming to you for what? Mine is a comment. We do not. Excellent. The mic is coming. Please.
Please stand. Okay.
Please stand when you're asking your questions. Thank you.
So, my name is Mike.
Hi, Mike.
Hi. And I have the mic. So, I have 2 questions. Number 1, let me put it as a scenario. You found a platform that's offering you free recording space, and then also you can edit your videos from there or your podcast from there. What are some of the things that you need to look out for? Because sometimes free is not always free. Number 2, this is out of curiosity. The Daily Nation published some of the copyright cases that have been there since 2015 the other day. And some of them are creatives versus very big corporates. So my curiosity was, are there things or pitfalls that people ignore? Because I'd assume these corporates have enough money for a good legal team, but how do they find themselves in such situations? So are there things that people ignore and then they find themselves in trouble? Yeah.
Get started with that. To be easy to remember. So free space, free recording, free. Ask them, where is the terms of engagement? What do I need to see so that I can sign? Give me a document. It's free. Don't just operate on it's free by word of mouth and good vibes and do your thing. Have it in writing such that if it's free for real, it's for free. It's also on a contract. It's captured that you have access to free recording equipment, free space, blah, 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 and you own all your IP and will not ask for anything in return. Have it in writing. So if they have terms and conditions or whatever document, make sure you have read it, understood it before you sign it, and then you proceed to record. The issue of some corporates finding themselves in situations where they're infringing on especially creatives' content, it's again a lack of understanding of IP laws. It's the lack of appreciating competent either lawyers or teams that understand IP. It's also instances where even the team, especially marketing, just were quick to move on their feet. So they didn't collaborate with maybe legal and, make the right decision. So that's how most of them find themselves in trouble. But equally, something I forgot to mention, and now that you spoke about case law, are we conversant with the Nonini case against the content creator? And that case was a big deal because, when Nonini sued this particular content creator, people were saying he was petty. Yeah. But it was Nonini's work, right? So again, even that speaks again to us as podcasters. When we are creating content, we have to be very careful in terms of the content or music we are playing. Because again, you're not playing it by coincidence. You chose. You decided, I'm talking today about drinking beer or whatever, and then I played XY song, right? So you have to be very careful because now we're talking about damages from 3 million. Because like in this instance, the content creator, I think, was fined 3 million. We have, at the tribunal, there was a matter we had, and we gave, I think, 4 million or 5 million. So we've been having some case laws at the tribunal as well. And we'll share some of them even with you guys so that you know what's happening and the stuff we are doing. So that you learn also from these cases. Yeah. Because then you don't make these rookie mistakes. So I think it's really, really important when we are working with content. Now, that's why I'm saying now as creatives and, creative movements, when we start having conversations with the other creative sectors, we can find ways to collaborate and jointly win. But please do not also, as a podcaster, be very careful with third-party IP.
Okay, another question. There's one at the
Hi, Akumu, Yes Girls podcast. Hi, Liz.
hosted on AfriPods.
Yes. Award-winning podcast. Anyway, hi, Liz. I have two questions. Personal experience. So the next one is a future idea. Where does social media content fall? Is it like fair use in terms of showing it or playing it in your podcast? That's the first question. And the second one is, we once had a guest. They came to our podcast, but it was our recording, and then they put it on their platform. So what should we be careful about in terms of if they start monetizing, what happens then? Yeah.
Okay. So the first question was? Yes, social media. So with social media content, you ask, who are you on social media? Are you posting as an individual or are you posting as a business? The minute you start posting as a business, there's no such thing as fair use. And that's why that content creator also got in trouble, because that was their business, and the business of content they were monetizing, right? But if I post as Liz, I'm making fun of something, I'm doing a dance challenge, because I'm doing it as me, I'm not promoting any services, it's fine. It's personal use, it's within exceptions of copyright, I'm safe. So always be careful, because I know we also have multiple accounts on our phone. So sometimes you're always so quick, post. Then you're like, oh, snap, I use the business account. Be careful. The minute you post as a business, if you've decided you yourself as a brand, you're a walking billboard and business, then there's no fair use in your regard. Again, Fiona, I don't know at what point you came in. Social media post. You're talking about social media. It can be. It will depend on the nature of use and how you're using it. If it's just a criticism or whatnot. So that's why I don't know at what point you walked in. I said sometimes you want an extra a legal eye to look at you if you truly fall into fair use, or maybe there will be some nuances we need to tweak for you to fall into fair use. So when you're using third-party content, you always must be very careful, because again, you see, as podcasters, you're not just doing it for fun. Also, you're hoping to monetize, right? So then because of that thin line, there's a way you have to be smart about it. It may be how you even do your wording or how you feature for criticism or whatever. So there I would say you need a legal eye to help you navigate it better. Yeah. Now, the second question, you had a guest and then they ended up posting. Did you have an agreement with them? You did not, yes, because we captured that and we said, when you're having a guest on your podcast, you must have an agreement for so many reasons, from a data protection aspect and also from a commercialization aspect for you as the investor, as the owner, right? Because you're investing, you're putting in money on the podcast, right? So you need to have that contract to protect your investment. So the minute you don't have a contract, your situation becomes complicated, right? Because they may even be relying on some conversation you had, right? So you don't want to leave things to any of your imagination. I thought you said, I thought we agreed. You know me, I do X, Y, and Z, so I thought you understood. Kill that. Have a contract. Yeah. But we can see how we can remedy that. We can see. But ideally, have a contract with your guests.
Thank you so much. My name is Greg. I'm very new to these kinds of discussions, so thank you so much for putting this together. So I have two questions, Liz. First of all, thank you so much for the insight. I've learned quite a lot today. I do have some things that would be considered basics, so please bear with me. So most of us, when we're starting off, whether it's a podcast or anything else we're doing, there's usually a business behind it. And most of us usually just go straight into, I have this idea, I probably register the business, I set up the website, I set up the social media. The website usually has a logo of some kind. Either we'll design it ourselves or have a friend design it, or ChatGPT nowadays. Yeah, so please advise us on what I need to do to trademark my logo or my brand. And if you could please speak about the process that is entailed. So, and also, what are the applicable jurisdictions for my brand, for my logo? Is it only protected here in Kenya? Is it a global thing? I don't know. And then my second question has to do with just general IP. Suppose I've identified a song already out there, a hit song, and I really, really want to use it in my material, in my production. So please advise on what I can expect that process to look like. Where do I start? Like if I'm coming to you, what does that process look like? Including costs, timelines, documentation I need to provide, etc. Thanks.
Unataka nimwage unga? I have to protect investment. You bring the brief, bring the bread. So let me answer it like this without making it look like legal advice, because again, someone may be misled by this video and say, but Liz said, and you see, we are doing this purely for educational purposes and infotainment, right? So I'll start with the issue of the trademark process. Trademarks take between 6 months to 12 months when the system is running well. Yes. Land. Because and international principles also, it usually takes about 6 months. When the system is on point, 6 months. It means month 7, you're collecting your certificate. However, there are administrative issues in the IP offices and whatnot. So depending on those issues, nuances and everything, that's when now it can stagger to 12 months, 15 months, 2 years. And I think the more Kenyans know about this, maybe we fight collectively, not just as lawyers. So that then you realize your lawyer is not lying to you. Legitimately, by the way, there's a problem somewhere. So it takes that long. And usually what happens is it's when you come to a lawyer, we will do a formal search for you to make sure that there is no similar registration in regards to the brand that you want to register. Again, remember, we'll ask you about your strategy, right? So that then, because IP is territorial, especially like trademarks, you're protected in the country in which you register. It's not like copyright. So again, as you're looking at your strategy, is your plan to actively market in certain countries? Is it Tanzania? Is it the US? Is it what? So that we're able now to assess when we register in Kenya, what's the next move, right? And then also with advice, and then maybe because of the costs, you may decide to change your strategy. Again, I mentioned about the classes, so that you have the right classes. Again, based on your strategy, you may want to diversify the types of, the type of business you're doing with your brand and commercialization and whatnot. So it may not just be a podcast. Maybe you're doing business trainings, then you're doing merchandising. Maybe eventually you might decide to have a coffee shop, because there's a way you envision maybe a podcast coffee shop, like there's 2 things you want to do, right? So we are able to help you figure that out, and we're able to now project what your legal costs would look like and your statutory costs would look like. Again, when you go to a lawyer, they're even able to tell you there's some brand names people bring, proposed brand names, we're able to say, even that one don't even touch. Go back to the drawing board, yeah? And again, on that note, we also interrogate who designed your logo, how was it designed, and all these things. ChatGPT, please move away. AI, move away. Legit, get someone to design for you, commission them, have a commissioning agreement, because you will own the copyright over the design, and then we also register the trademark because you're using it to trade. So there you have like 2 assets. So you have to be very careful. Again, you mentioned that issue of where is your friend who designed. I've had a situation where a client had their friend design. Then it turned out that it was some picture they picked off the internet. We did a deep dive on the internet and we found the picture. And he said, boss, did you even do your research as well? Like, how did your friend just blindside you like that? So you have to be very deliberate, because at the end of the day, when you use it, nobody will care you commission someone. See, you're the user. So any liability will fall upon you. So you have to be very deliberate with that. Then what was the second question? The song.
Process of IP.
Oh, yeah. Okay. So the hot songs, I have been in similar situations where I had a brief like that. It was hot songs being used by a client, hit songs and whatnot. So we had to do our homework. So I'd say if you're dealing with a hit song, you're better off with a lawyer. Because then what we will do is we'll do the homework. We confirm with you first the nature of use, how you're using it, all these things, everything. Then now we do the homework. Now we're able to say who is the copyright holder, who's the sound recording holder, are they represented by a publisher, are they represented by the record label, and then we start reaching out to them. And that process may depend with how fast also the other party responds, right? So again, that's why you don't be shooting the content tomorrow and you're coming to me today. It's not going to happen. So again, as podcasters, you have to project your content. Yeah. You have to, curate your first season, for example. You're able to say, this is what I'm looking at. So even when you're coming for protective lawyering, we're able to anticipate your legal needs and we see the complex issues and we start dealing with them beforehand. So if you're shooting on week 12, at least week 0, we have started some work, right? And we've been able to say, okay. And then if it's something we may not be able to assist, like clear the song, we are able to give you plan B, right? Because we may have access to some songs that are easier to access and we're able to say, oh, what if we use XY because I've worked with so-and-so before? I think they're an easier publisher to use or whatever, I'm able to give you projections. But generally, again, the legal fees will depend on how heavy that burden is. So the more, if I'm dealing with a US publisher, that means at midnight I'm awake, depending on which state they're in. So I'm just waiting to receive a call on behalf of Greg. So of course then the legal fees must reflect that hard work. Yeah.
Is there another question? Oh, there you go. I see 2 more. Hi, Keshi. I see 3 more questions. Oh, 4 more questions. Okay. Is that a 5th?
Guys.
Okay. Yeah. No.
She's asking and she's asking.
Wondering what was happening. Hi, thank you so much. And you are right, she's Beyonce in legal and IP.
I don't play with my people, guys.
It's because I followed her. I'm an advocate in the IP space as well. So I followed your work since I was in school. And now it's really a privilege to be here and to listen to, because I also listened to you last week in Strathmore when you're talking about broadcasting. And I find that IP is very diverse, but also it changes a lot, especially for people like me, young lawyers who are coming into the IP space. Which platforms are there for now us? Because it changes so much. And then the number of IP lawyers are also not many. So you find the resource itself, as compared to like a criminal lawyer, there are so many hata jivanji wako. So sorry. So IP is very special. Which platforms, where are there mentorship spaces for IP lawyers? Yeah, thank you.
Okay. As the mic is being passed around, let me answer your question. So as you've said, IP is very dynamic. So the first thing you want to do is be in relevant spaces like this space, right? Because also you are working, you're near creatives and you're able to hear their challenges. And then you're able to relate and isolate what legal principles are there that you may need to research on. You may not know them immediately, but then you're able to research on them. And then secondly, it's always important to keep up with especially the international markets that are more advanced on IP issues, especially the US and Europe. So again, you'd want to follow the platforms like the USPTO, EU IPO, and what WIPO is also doing in terms of conversations they're having, developing issues around copyright. Then that way you walk steps ahead. Of course, looking at what international creatives are doing. Before our influencers were being sued for non-compliance or breach of agreements, like for me, I was ahead. I knew of a British influencer who was influencing for a certain luxury brand. And then in her contract was specific that she can't be seen in public spaces buying competing brands. Then she was busted. and she lost an endorsement into the whole situation. So even I started advising clients and said, hey, it may not look like an issue in Kenya. However, protect yourself so that then when you walk ahead, you're able to prepare your clients ahead. Maybe next year we'll have some other CPDs on entertainment and whatnot. Please show up for them. But even at Strathmore, we try and have IP-related courses. Unfortunately, lawyers are not turning up. Yeah, so like earlier this year, we tried to have one for fashion law. We had only 2 people register. So then we decided to abort mission. So we'll exchange contacts and see if maybe you have a pool of young lawyers somewhere. Maybe they just are not in our platforms, especially if you're Gen Z and us, we're marketing on Facebook. It's a problem, right?
Get on Snapchat.
So maybe we need to advertise on Snapchat, as Gadoni is saying. Yeah, and then do the courses. Coursera, edX, WIPO has some free courses. You want also to do those ones so that you are up to date with what's happening. Yeah.
All right. Hi. Hello, everyone. My name is Richard. I have 2 questions, very short ones. First one is on self-lawyering.
Don't do it.
Do I have a lawyer called Gentleman's Agreement most of the time? So for the things that we have tried to do in creating content with a few other people, we have written down stuff and signed. Yeah. I wonder if there is legal issues later, what papers hold weight? Like the things we signed and read and had another friend as a witness, does that count? Or to what level do I need to have every piece of paper written by a lawyer? Because, for example, if I'm doing collabs a lot, I'm doing partnerships, I write them differently depending on the kind of engagement. I don't know if I should engage a lawyer every time because then again, that's a lot of money. The second one is not a comment, it's a question.
I was about to take the mic away from you.
Second is it's not a comment, it's a question, but
it's a comment. Put a question mark at the end.
Yeah. It's quite technical. So I'll go into it right away as an exact scenario because you've given the example of Nonini and a certain creator who used the song in a video online. However, on platforms, songs are available. Yeah. So if you're doing an Instagram story, there are billions of songs there to just do whatever, just do the song. TikTok, same thing. Yeah. If I'm trying to be sneaky about it, well, there are 2 scenarios. There's doing a video and editing music into it. Yeah. So I've done an advert. I've put in music from Nonini and edited into the video. There's me doing a blank video with no audio, put it on the story, attach a song that's available to me. Do I need to ask Nonini to allow me to use his song on my story or on a TikTok? Because Technically, I didn't edit the music in. It's there on the platform. I just uploaded. Platform gave me the song, put it in there, ran my ad for my podcast, and I will say technically I didn't use the song. I hope that's, just help me with that bit of the confusion.
I think first you need an applause for those 2 questions. Those are very good questions you've asked. So for the first question about self-lawyering, if you come for the initial consultation, you become equipped such that now you can self-lawyer on non-contentious issues, all right? Because now you will come from a point of information. You've gone to an IP lawyer, they're able to assess your business needs, your IP needs and whatnot, and they're able to say, oh, this is what you want to do. When you want to do A, this is what you want your contract to look like. When you want to do B, this is what you want your contract to look like. One of the earliest case laws in contract law was 2 people who signed a contract on a serviette in a bar. And it was upheld in court as a contract. So it doesn't matter. What matters is the 2 of you understand each other. and what you're doing and what your gains are and what your obligation. That's all that matters, right? So once you've been prepared in that initial consultation stage, then you're able to navigate such that now you're able to even protect yourself. And now you'll be able to now have your contracts in place and even know, because there's some contracts, maybe just even 5 or 6 clauses, and they still help you, protect you, and you have the right things in place. But from a self point of information is really important. So if you have that initial consultation and you're empowered with information, then now you can actively self-lawyer, and then you will even know when I can't self-lawyer. When I know red flags, like call somebody. Yeah. Then that question on songs. Just because it is publicly available does not mean it's free. Secondly, I said, if you're posting as a business, so you're in content creation, so you are an influencer, you are managing a platform for brand X, maybe they sell shoes, maybe they sell coffee, maybe they do what. Just because that song is there doesn't mean that you have to use it as a business. You can't. Yeah? You must get that license. That content creator, that's what they did. They were marketing phones. And then they used Nonini's songs. Nonini has attended so many of the trainings I've done and then some. So he knew what to do. Yeah? So now you know what not to do. So much so that now if it's a song, your friend is an artist, and they say, yeah, you tumia bure, tumia sare. You're able to say, boss, shika contract. Confirm ni free in writing, yeah? And then you have it as a backup. You sign, send each other a scan. You have it saved in so many places. Because again, you may lose your phone, you may save it in the cloud. So that you always have evidence. Akidecide kuruka story, uko na evidence. Because the proof is in the pudding, and the pudding is the contract. Yeah? So social media, if you're posting as a business, just because it's publicly available, see free. If I'm posting as Liz, I'm easy. But even me, sometimes I have to be careful. Again, because even you as an individual, depending on what kind of esteem you hold and whatnot, you don't want also to look like you're doing freebies, free advertising. So sometimes you have to be smart, not only as a business, but even as an individual, right? Yeah.
Okay. I see 2 hands that are up now, and there's one with the mic. So Kevin and then Keshi after him. Okay.
Hello, my name is Harry from Ngori Media, and I have a question about the repurposing, because there's a podcast we did, and I didn't want the guests to repurpose the content for how they did it. So is there a way that I can protect the podcast from being repurposed in a way I wouldn't want on different social media sites? And another issue is on because we record the podcast in a studio where there are different musicians and artists. So in a situation at the end of the podcast, an artist started singing their song, and then a couple of other people who are around, they played guitar, another person played piano, and then it was like a whole band thing. So is there a way to protect that content from, say, let's say the artist says it's theirs, or whichever artist decides to say that they own it, such that I'm the one who recorded it, so I'm the one who owns it. Yeah, thank you for the talk.
All right. So the first question was, because the second question, repurposing, yes. And I spoke about contracts. Remember, I talked about the guests you're having, whatever access they may have, whoever you're working with or collaborating with, whoever you're outsourcing as labor or tech team. You have to have very clear contracts. You have to assert your intellectual property in the recordings and all that content, and show you it's yours, it's you to control. So much so that if they did it, you will sue them very fast, right? And they can see on the contract they've done wrong, so they wouldn't. That's why I said you always have to be clear from the beginning, so that you protect yourself. And even again, remember I said copyright gives you moral rights. Yeah. Again, so you're able, just on even the grounds of moral rights, even in the absence of a contract per se, but we have evidence to show that it's your work, it's your content and all that, right? Even just on the basis of moral rights, you can take that content down. And then if you decide to even pursue further, which is teach this person a lesson, you can do that. But you always want to have a contract in place. It's easier, it's faster, it's less messier, and you've asserted yourself. You're basically saying, if you don't agree to 1, 2, 3, 4, we're not even working together. Next. Then the second question was regarding the music playing at the end. Again, you sound like even you're deliberately recording in a music studio, right? So you remember when I talked about consent, you can even before the podcast tell them that you might decide to record a song. Yeah, yes. Do you agree that because this recording is mine, you accept that this is mine, you won't claim anything? Yes. But if you decide to reproduce the song and now go and record it in studio properly, it's yours, right? Sawa. So this is mine, but if you want access, I can give you for within certain parameters. That in itself even is a contract. Then say, yes, I agree. Yes, I agree. Whoever says, yes, I agree. Yes, I agree. Start shooting. If you try to do it after the fact, it might be difficult because they might think something you're up to no good or something. But if you do it before the fact, maybe even they'll decide to do that song for the heck of it. But at least you'll have protected yourself, and you're in a space where you already anticipate that happening. So because you anticipate that happening, then proactively protect yourself beforehand. Yeah.
Kevin.
Hello, everyone. Kevin. Liz, thank you so much. This is really, really insightful. So I had a question for you. We're talking a lot about music and, the copyright of it, or trying to get permission to use. What are your thoughts on us using websites like Envato or Soundstripe or Epidemic Sounds who have copyright-free music? What do you think about that? Because that might be a way for us not to have to go through a lawyer and, so much red tape in order to use sounds that may make our pod sound better. And then my second question was, for those of us who might be interested in syndicating our podcast on like the radio, what are some of the things that we should be looking out in regards to that? Because we'll be looking to essentially give the radio show permission to use our pods, but not necessarily the rights to it in terms of ownership. So I was wondering what your thoughts were.
All right.
Thank you.
So first question, I talked about terms and conditions regarding most of these platforms. So yes, they say free, royalty free or whatever, but you have to read the terms and conditions. Sometimes, most cases, these terms and conditions are very verbose, jargon, so much English, big words, you may not understand. So have someone just proofread for you. And then you're always alert whenever they ping you for updates, right? Because what may have been in the terms and conditions 3 months ago may have changed when they pinged you and updated you. And you see most of those sites say, if you proceed, then you have accepted the updates and blah, blah, blah. So now you're bound because these are pop-up contracts, you're legally bound. So you make sure you read. So just because they have said they have a marketing gimmick saying it's free, royalty free and blah, 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 you must read the terms and conditions. Because by default, when you use that website or that content, you have automatically been bound by those terms and conditions. So then you must know, what am I being bound by? Am I liable for anything? Some of these sites, by the way, you find they've not even cleared some rights. Those people who like to use these picture stock images. Hey, let me tell you. Just because that person looks like they're British, they're what? Kwanza woe unto you if that person is a European and you use their picture. GDPR will chew you a good one. And some of these platforms, they even, when you read the fine print, they say, we have not cleared any copyright, image rights, blah, blah, blah. And you are there, oh, it's free, ding, upload, use. Be very careful. So read those terms and conditions very, very carefully because you never know how it might bite you. Was there another question? Yes, with broadcasters. If you're going to bed with a shark, you better have a shark by your side. You want to get into a partnership with a broadcaster, my friend. Those are people with the money, with the audience. Yeah. So what's that saying? He who pays the piper pays the tune, something like that. Yeah, that's saying. So whoever has the cash, has the clout, has the investment, be very careful. So I would say in such situations, you're better off discussing with an IP lawyer to help you make the right decision or negotiate for the right stuff, right? Because then we're able to negotiate for any royalties, any revenue that they may have around ads and whatnot. We're able to see if this deal even makes sense. Are they, quote unquote, lying or misrepresenting? Is the deal too good to be true? Are they able to deliver what they are promising? How long is this, agreement going to be for engagement? What does it mean for you? What does it even mean for your future content? Yeah, they're very clever. They even tie your future content, just like what they do with musicians. And you're just there like, oh, X amount of money every month. Yay. And then you realize at some point you can't do what you want with your content because you tied yourself somewhere. So make sure if you're going to bed with a shark, please have a shark by your side. That's what I would say.
Keshi?
My name is Keshi. I work in the comms and marketing team at Coffeesy, and I love this conversation because I deal with podcasters like every day who want to book the studio. So my first question is, I have two. My first question, you talked about podcasters being careful with local and international copyright laws, and then you mentioned something about Kenya, we're under this treaty thing. Could you expound on that? Like, I just want to know the name, or like, does South Africa have a different treaty because we're in multiple countries and because I could be a podcaster there? So expound on that. And then the second question is, because I'm also a content creator, for podcasters in the room, because I know you own my IP legal studio, are you comfortable sharing like a rough rate of how much you would charge to be an IP lawyer for someone like me, a podcaster or a content creator? Or is it something we have to consult you separately for? Because for me, I'm just like, one, I need an IP lawyer like yesterday from this conversation. And two, I need to know if I can actually afford you because I need to hire you like ASAP. So could you expound on that?
You can start saving today to afford Beyonce.
Let's start with question 2. I would yell my fees for people to hear, but I'll say, make me your friend when we're still protective lawyering and you're good. I'll make sure you're never in trouble. And of course, like I said, protective lawyering is cheaper than defensive lawyering. So rest assured, you can afford me. Yeah. Now, to the question about international local copyright laws and everything. So we know that local laws are born from international conventions under the UN, right? So with IP laws, we're under the World Intellectual Property Organization. For the different areas of IP law, we have different international conventions. So for copyright, we have the Berne Convention, which set the minimum of how copyright is protected and asserted in the different countries who are signatories. And it's a majority of the countries, right? And it's the basic principles. If it's not yours, you clear the rights. Same treatment. If South African content is being used in Kenya, treat it as local content, as you would treat local content, which means clear the rights, compensate, do all that due diligence to make sure. It means that just because they are not registered doesn't mean they can be protected here. Because the misconception we always had is, it's international. They won't come after me. Hey, and the day they come after you, where? Utauza hadi fridge. So you want to be very careful. So just because it's international doesn't mean it doesn't have a somebody. Yeah. So you have to be very, very careful with third-party content and protect it. So that's what I was basically saying, that they're not subjected to some formalities, that there's some basic minimum, which we already have at a local level, and that is already at an international level. And it's just that if it's not yours, clear the rights, make sure you do the right thing, understand, that if you don't clear it, then you're going to be in trouble. Can you afford the trouble? Probably not. You don't even want the trouble to begin with. Because again, if you decided you wanted to sell this podcast, nobody wants to buy a business that's in the minus, litigation, So even such that now even this brand, yes, you have a trademark, but there's so much liability, from litigation liability to maybe even poor business practices that pass. And maybe you had good content, but now they wouldn't want to invest because you're just a red flag. Yeah.
Okay, the people who... Okay, I'm seeing someone whose hand was up before. I want to give someone whose hand wasn't up. The other two people had their hands up before. You can see Liz on the side as she said, "Hi so much." Hi, fine. So I think I didn't have a question. You haven't said your name.
My name is Nyambura Gomba. I am a sister to the host and her co-host. So maybe this is... You're doing... We're fighting mediation. Mediation. No. The question I have is, I think a lot of the information you've given us is, like you're saying, preventative or preemptive. But what I'm wondering is, in a situation like maybe what Akumu has shared or what he shared, we didn't have an agreement. That one, it's already out the window. It has gone, right? But... And maybe it's that gentleman's agreement of, you've come to my podcast. Granted, you also have content that you contributed by answering the questions, etc. Does that mean that I have no recourse if I'm not happy with the way you have chopped up? Let's say my format is usually 45 minutes, whatever. But then because you are on my podcast, we didn't have an agreement. I've given you the content. Then now you have edited just my voice over something else, that kind of thing. I guess this maybe falls into the defensive side, but what do I have as, or what should I do outside of coming to call you and not fighting on social media? Is there something that I can do about it? Yeah, is the question.
And that's a good question. Stay.
So yes, there's something you can do. Remember I said we have to fight smart, right? So by fighting smart means sending an email and saying, "Hey, dude, I know we didn't have a contract, but guys, see, this is my content and we agreed you're coming on my platform. Aki, please put that content down, but put it in writing, Because also you're also putting together a body of evidence, but you're now doing it polite and hoping that the other party will come politely. So much so that now if things go really badly, then you're able now to say, "Hey, Liz, here's the evidence. Next, what can you do for me?" Because in such a scenario, there are situations where artists or copyright holders will walk away from their rights because they think their goose is cooked, or because they just don't want bad blood. And I'm about good vibes. I'll create another one, moving on swiftly. See, that's what we normally do. But half the time you'll find there's a way we may be able to help you. So that is the soft strategy. And then when that hit does not, we crack the whip and we say, "Are you ready?" Because this might mean you guys won't talk for the next 3 years. Is this a relationship you're ready to lose? Because we can see that this person also does not want to own up to their mistake or does not want to respect your IP and blah, blah, blah. We give you that analysis. You make the decision and say, we know we've had situations where it's always hard when someone tells you, "Be soft but hard." How's that going to work, And sometimes you have to just now tough love and crack the whip, and now it's war. Because the stakes are also high. IP is also property, right? It's your intellectual property. It's your shamba. So again, if you have that culture for fighting soft and you're in business, utakula nini? Yeah? What are you going to bring to the table at home? What are you telling your kids about being a creative? Are you saying you just sit and just take blows and hopefully good vibes, inshallah, the world or the universe will give it back to you? What? Yeah? So yes, like I told Fiona and I told the other gentleman that if you feel like inawasha, nione kando.
Okay, so umesema ikiasha tukone kando. Where can we find you after this? Okay. Are you hanging out? They said yeah.
So after this, I'll share some business cards. I have some business cards. I'm usually, once you have my business card, I'm accessible more on WhatsApp. My life can get hectic sometimes, but usichoke kuping. But if you do an email, because then that shows that we are serious and we want to get into business, it's easier. WhatsApp can be very informal, and it's sometimes can be hard to follow up with, especially with my business line. But I'm also on social media. I do a lot of also content in terms of educating the public. This is my CSR. This is how I give back to the community. I share knowledge. So
Community is grateful.
Yes, thank you. So I try to educate creative. So if you just search me on Google, Utanipata, you will know where to find me. You will know where I'm speaking next and what I'm speaking about. And you show up and come and learn the next level of what you may not have known. And then if you have any case in terms of copyright disputes, our email is copyright@court.go.ke. You send an email and say, I have this kind of issue. Help me file. What do I need to do? And our team will help you and give you steps and links to the respective areas you need to address and what you need to do. The copyright tribunal is virtual, so you don't need to show up in a court, umevaa suti and mastering all your English. We also listen to matters in Kiswahili, even in Sheng. As long as we understand each other, and even us, if you're using Sheng and there's a word we don't understand, we'll ask you, hey, hiyo unasema. But we strive to make sure that there's an understanding between us, among us, and all that. So that means wherever you are, you might be here in your little space, you go to that booth, log on to the tribunal link, you're in court, do your thing, or witness your lawyer do your thing. And then you come back to your space and continue working. So you don't need to, you're not attached to any formality. So it's really easy to use. So I really hope that we'll use some of these dispute resolution mechanisms, because the more we test the law, the more we know what kind of improvements we need. Cindy, if we're not testing the law, then even us as lawyers and policymakers, we don't know what next for you, right? We can only test what we have and then say, okay, maybe we need another section that can do 1, 2, 3 for creatives or for this section of people. So soon there will be a conversation around the copyright bill. We have a copyright bill now. We want to overhaul the Copyright Act, an initiative by the Kenya Copyright Board. So when such conversations are happening, please come, show up, access the document, find a way to read and make some questions, sit as collectives, debate, have a conversation. What do you understand? What do you want to see? Because the plan is that this copyright bill will be comprehensive enough for all copyright industries. So, you need to ask for what you need, and we can only get it from you. There's only so much as we know from this end, and then there's stuff that you're experiencing on the ground that you need to explain. But it's been a pleasure.
What's the handle on social media?
My handles are generally Liz Lenjo _Kags. That's my marital name. So you find me LinkedIn, it's Liz Lenjo, but in the others, it's Liz Lenjo Kags. I'm asserting mtu wangu pia.
Hautaki confusion?
Staki confusion.
Excellent. Thank you so much for making the time to be here. I believe we had a good time, yes? Did we learn? Excellent. I want to say thank you to Semabox. They're our technical team, our technical partners. Thank you so much for recording this. It'll be available on YouTube later. So if you have forgotten or you didn't write a note, don't worry. We will have it later available on YouTube. Thank you to Baraza Media Lab for being amazing hosts at Dongo, Javan. You're the best people. I want to say special thank you to Main, our photographer. The man with the connecting beard is what I call him. He's at the back, so don't worry, I'll send you the link for the photos. And I want to say thank you to Jesse also. He's doing social media for us. Jesse, please wave. Okay, now after this, Jesse is going to come and ask questions, okay? He's going to ask you what you thought about the session. He's going to ask you, do you have podcasting tips? Please talk to Jesse, okay? Because if Jesse talks to you, more people find out about this, more people learn. So we want it to be open for a lot more people. Thank you for coming. Kofisi have an event on the 14th of August for creatives. So check Kofisi Africa as well. That one will have KRA leakage. So if you want to find out now the taxes, after you have called your lawyer and found out how to get people. Now come for that one. You'll be able to get a lot more information. So thank you everyone for coming. I have been your host. My name is Gathoni. Follow us at AfriPods on all social media platforms. We offer free hosting. If you have a podcast and you're not an AfriPods, honestly, what are you doing at this time? What are you doing? My handle on social media is Podcasting in Africa. Follow me. I give podcasting tips. And if you have any questions, let me know. It was good to have you. Thank you all for coming. Have a good night.